So Dickinson v. Dodds is another sort of old-timey decision that can seem a bit complicated at first glance, but if you break it down, it's actually a pretty straightforward case. So this case is from the year 1874, and it comes from the British Court of Chancery. So this is not an American case. And one of the confusing things about this opinion is that it is written in the seriatim format, which means that judge each judge writes an opinion. And the holding of the court as to who wins this case sort of comes down to which side a majority of the judges agree with. So in this case, there were some judges that thought Dickinson should win. There were some judges that thought Dodds should win. But at the end of the day, more judges thought Dodds should win. So that was the decision of the court. So they say Dodds wins. But some of the judges say they would rule for Dickinson and give their reasoning. So it's a little bit confusing, but just know that the holding of this decision is that Dodds wins. So let's talk about what happened in this case. So, gonna make a timeline. And what happens here is that on June 10th, Dodds makes an offer to Dickinson. And this offer is a contract to sell his property. So Dodds is offering to sell his property to Dickinson. And in the offer, it states that the offer will expire on 6/12 at 9 a.m. Okay, so Dodds makes the offer. Say Dodds offer expires. Okay, so this period of time, which I will color in red. So this is the period of time in which this offer is going to remain open for Dickinson to accept. So the offer is made on 6/12 or 6/10. The offer is made on 6/10, and the offer states that it will expire on 6/12 at 9 a.m. So Dickinson, having received this offer, pretty quickly decides that he wants to accept it, but he also decides not to tell Dodds that he's accepting because he has until 6/12. So his plan is to wait until the deadline or just before the deadline. And then Dickinson's plan is to tell Dodds that he accepts. Now, the issue comes in that the next day after Dodds receives this offer, so on 6/11 at 12 p.m. So on 6/11 at 12 p.m., Dickinson learns that Dodds sold to Allan. So on 6/11 at 12 p.m., Dickinson learns from a third party that Dodds had just sold the property to a guy named Allan. Okay. So 6/11 at 12 p.m., Dickinson learns that the property has already been sold to another person. And so Dickinson ends up scrambling and uh, gets someone to deliver a letter. And on 6/11 at 7:30 p.m., Dickinson accepts the offer. Okay, so 6/11 at 7:30 p.m., Dickinson sends a letter to Dodds's house. It says that the decision says that the letter of acceptance was delivered to the mother-in-law, and there's some issues about whether or not the mother-in-law forgot to give it to Dodds. Doesn't really matter. We can assume, for all intents and purposes, that Dickinson had accepted the offer on 6/11 at 7:30 before the offer was set to expire. And then Dickinson, just for good measure, on 6/12 at 7 a.m., again, before the offer expires, uh, he hand delivers a letter directly to Dodds saying that he accepts. So, on either 6/11 at 7:30 p.m. or 6/12 at 7 a.m. It doesn't really matter which one, but at some point, Dickinson accepts this offer and provides a notice to Dodds that the offer has been accepted. Um, and Dodds replies that Dickinson waited too long, that he had already sold the house to Allan, and ends up, just going forward with that deal. And so Dickinson sues. So, what the Court of Chancery ends up holding in this case is that the 6/10 date where Dodds gives the offer to Dickinson. This is the offer. And then when Dickinson learned that Dodds had already sold the property to Allan, this was a revocation of the original offer. Okay, so the court, when it's discussing this issue, is basically saying that Dickinson learned that Dodds had taken an action that was inconsistent with the offer that he had made to Dickinson. And that put Dickinson on notice, basically informed Dickinson that Dodds's offer was no longer open, that Dodds had made the decision to revoke the offer. And once Dickinson learned that the offer was that, Dodds wouldn't be able to make good on that offer, that constituted a revocation of the offer. And because the acceptance happened after that revocation, okay, so because there was an offer and then the offer was revoked before it was accepted, this means that there was no contract. Okay, so Dodds makes the offer on 6/10. On 6/11 at 12 p.m., Dickinson, by learning that Dodds had sold the property, that told him that the offer was revoked. And when Dickinson tried to accept the offer on 6/11, at 7:30 and on 6/12 at 7 a.m., in either instance, that acceptance was occurring after the offer was revoked, and so there's no contract. Now, you are probably asking yourself, but wait, what about this expiration? The offer said that it would be open. The offer said that it would be open until 6/12 at 9 a.m. So that told Dickinson that he had all the way till 6/12 at 9 a.m. and he accepted within that expiration time frame. So if he accepted before the offer expired, shouldn't that mean that he gets the contract? And the court says no. And so this is the takeaway, the key takeaway from this case. I give myself a little bit more room here. So this is the key takeaway, that an offer can be revoked at any time before acceptance. And that is true even if before even if before the expiration. And so what the court holds is that even though this offer that Dodds made to Dickinson said that it would be held open until 6/12 at 9 a.m., even though that was what the offer said, Dodds had the right to revoke the offer to Dickinson. So what the court says is that even though Dodds said that he would hold the offer open till 6/12 at 9 a.m., he was not under any obligation to actually leave it open, and he was free at any point before Dickinson accepted the offer. Dodds was free to revoke it, and the revocation occurred on 6/11 at 12 p.m. And once that offer was revoked, it doesn't matter if that was before the expiration. Once the offer is revoked, it's dead, and Dickinson is no longer able to accept it. And your instinct in this situation might be to say that's unfair, that if Dodds told Dickinson that he was going to hold the offer open till 6/12, shouldn't the court hold him to that promise? And so this sort of leads us into the topic of consideration, which you may recall from the Introduction to Contracts video. Consideration is an element of a contract, and it sort of has two parts. And part one says that you get what you pay for. And second, that you don't get what you haven't paid for. Okay? And so consideration is an exchange of things of value, or a quid pro quo, something that's being traded between two people. And the rule is that if you've paid for some sort of privilege, or right, or thing, property, whatever it is, if you've paid for it as part of an agreement with another person, then you get what you paid for. And if you haven't paid for anything and someone is simply promising that they'll do something for you, you don't get to enforce that promise through the courts. Okay, so that's what the rule of consideration is, and it's an element of a contract. If you haven't paid for it, then you don't have a contract. And if we return to this timeline, we have Dodds making the offer to Dickinson, and he promises to keep the offer open till 6:12 at 9 a.m. Okay, that was his promise. But notice Dickinson didn't pay anything for that promise. So if he didn't pay for it, he can't enforce it. It's up to Dodds whether or not he wants to honor his promise to Dickinson. And so Dickinson does not have an enforceable contract at this point to enforce this deadline, okay? And there is actually a type of contract. There's a type of contract called an option contract. And what an option contract is you pay for the option to accept an offer. Okay, so what this says is that had Dodds paid Dickinson some form of money or, some other thing of value, if he had paid Dodds to keep the contract offer open until 6:12 at 9 a.m., that would have been an option contract, and then the deadline or the expiration date that would be enforceable against Dodds. Dickinson would have been able to enforce this option contract. He would have been able to force Dodds to accept his offer at any point before the deadline. But because Dickinson didn't pay Dodds for this expiration date, he has no right to enforce it against Dodds, and Dodds is free to revoke it at any point before it's accepted. Now, one wrinkle to keep in mind is that this probably only happened because Dickinson learned that Dodds had already sold to Allan on 6/11 at 12 p.m. If Dickinson had never been told that the house had already been sold, and he ended up making his acceptance thinking that it was still available, this case may have turned out differently because it's not clear that there would have been an effective revocation at this point. So the reason that Dodds wins this case is because the court treats this moment as a revocation on 6/11 at 12 p.m. And that was because Dickinson learned, even though it was from a third party, it wasn't from Dodds himself, but Dickinson learned from someone else that Dodds had already sold. And once he learned that, he had no expectation to be able to accept that offer, and the court treats it as a revocation, as though Dodds had told Dickinson directly that he was revoking the offer. But again, if Dickinson hadn't learned that the property was sold, there may have not been a revocation that the court would recognize, in which case Dodds may have been in some trouble when Dickinson accepts the offer before the deadline. So it was kind of, Dodds kind of got lucky that someone else told Dickinson that the property had been sold. Otherwise, Dodds may have been on the hook in this case. But the key takeaway from this case is that even if a contract offer provides for its own expiration date, provides a deadline to be accepted, it can still be revoked at any time before it's been accepted. So this puts the onus on the person who receives an offer to either accept it or else risk having it be revoked. Or if you want to have this time frame, this whole time frame to decide whether or not to accept the offer, you need to pay for the privilege. You need to provide something of value to the person who's making the offer in order to hold it open and make the decision. And if you pay for it, if you pay for the privilege to have all the way till this point in time to accept a contract offer, then that deadline will be enforced. But if you haven't paid for it, then you don't get it.